My name is Carly, and I'm an employment attorney at the Manifest Justice Law Corporation. Today, I want to talk to y'all a little bit about retaliation, break down the elements of how to bring a valid retaliation claim under the FEMA Fair Employment and Housing Act regulations. So, retaliation can seem a little bit complex, but understanding the 5 core requirements is the first step to help you better understand your rights. So, let's break it down. There are 5 requirements that a person must meet in order to bring a valid workplace retaliation claim under FEMA regulations in California. The 5 elements, just quickly, and then we'll dig in deep and we'll double click on these. But the 5 elements, it's protected activity, adverse action, causation, harm, and time. Those are the 5. Okay, so what do those mean? Let's break it down a little bit. So the first element is protected activity. What the heck is a protected activity? The first element that you must prove in order to bring a valid workplace retaliation grievance under FEMA is protected activity. The first element of protected activity says that the person who is claiming retaliation has to have engaged in a protected work activity. So that means something like reporting some unsafe work conditions or participating in an investigation to uncover safe work conditions. That means asking for a reasonable accommodation. That means reporting, again, like harassment or discrimination, or policy violation, the workplace policy, refusing to work when there are unsafe conditions, or reporting illegal conduct. If you see a colleague doing something or a supervisor, you know there's something going on. But it's basically like reporting or participating in an investigation or asking for an accommodation. But it's basically when you speak up. That's kind of a protective activity. Speaking up about things that you see in the workplace which could cause harm or an emergency. When you're engaging in a protected activity and you're reporting something or you're speaking up about something, you could be wrong. Okay, I just want that to be very clear. You could be speaking up about harassment, and actually, it's not harassment. It wouldn't be qualified as harassment. Or you could think someone was being discriminatory toward you, and so you tell someone at work, and actually, it wasn't discrimination. You just genuinely had broccoli in your teeth. They weren't doing anything to make, again, like discriminate against you as an individual. And so it wasn't discrimination, but that's still protected activity for you to speak up about something, whether or not what you're speaking up about is valid or real or actually happened. That's going to be protected activity. So that's the first thing. The person who claims, that's the first element. The person who claims retaliation has to have engaged in some form of a protected work activity. So the second element that you have to prove in order to bring a valid workplace retaliation claim under FEMA is that you have to prove that your employer took some form of adverse action against you. So that could be anything from firing, demotion, denying your request, discluding you from meetings, talking about you in Slack messages or emails, but it's really any kind of like negative employment treatment that's related to the protected activity. The third element you must prove in order to bring a valid workplace retaliation claim under FEMA is causation. So you've got to show that engaging in that protected activity caused your employer to act adversely toward you, to take adverse action against you. So, in other words, you need to show that your engaging in the protected activity was at least a motivating factor, at least part of the reason why your employer took an adverse action. So, if you put in a request for a reasonable accommodation and then all of a sudden you were demoted, it's on you when you submit that claim under FEMA. You've got to show the connection that directly after you asked for this accommodation, you were demoted, and there wasn't necessarily any other good cause for denying you that promotion or for demoting you in general. If you reported that you saw someone sexually harassing another employee, even if you yourself were not sexually harassed, and then all of a sudden you are removed from a bunch of projects at work, you've got to then prove that you being removed from the projects at work is directly related to you reporting the harassment that you witnessed. The fourth element that you must prove in order to bring a valid workplace retaliation claim under FEMA regulations, the fourth element is harm. You've got to prove that you, the employee who engaged in the protected activity, experienced adverse action that was caused by the protected activity, you've then got to prove that it harmed you somehow. You faced an adverse employment action, or maybe you've gotten an injury because they didn't fix the unsafe working conditions. And so now you've got a workplace injury on top of it. It could be a mental or emotional injury. You've got to have some type of harm related to your employment And whether that's an adverse action that was taken, again, you were demoted, you didn't get the job, you were removed from projects, or maybe you suffered a physical injury because you complained about unsafe working conditions, the employer didn't fix this unsafe working conditions, and so then you were injured on the job. Perhaps you have a psychological or emotional injury, but harm is pretty broad here. There's just got to be some kind of harm as a result to the previous chain of events. The fifth and final element that a person must prove in order to bring a valid workplace retaliation claim is time. So you've got to submit your grievances within 3 years of the retaliation happened. So whenever you engaged in the protected activity, that's not when the clock starts. The clock starts once you faced adverse action. As soon as you face adverse action, the clock starts ticking. You've got 3 years to submit your claim. So put very, very simply, did you engage in a protected work activity? Did you face retaliation as a result? And then were you harmed by that retaliation? If you have all three of those, and again, there's additional elements, but if you have all of those, you submit it within the time, you can prove causation, you may have a valid workplace retaliation claim. If you live in California and you feel like you may have experienced retaliation, or even if you just have questions, please feel free to reach out to us at the Manifest Justice Law Corporation. We will provide completely free, zero out-of-pocket charges consultation. It will be trauma-informed, culturally competent, and client-centered. And there's absolutely no pressure to move forward and pursue a claim if there is one. But we will help you understand what's going on at your workplace, better understand your rights, and help you figure out what's your best next step. If you don't live in California and you feel like you may have experienced retaliation, please, please, please reach out to your local bar association. Bar associations typically offer free legal referral services and they can help you get connected with an attorney. If your local bar association does not offer free legal referral services, you can typically still call them and tell them what's going on. They can at least help point you in the right direction to get you started in looking for counsel. But help is out there and it does exist. So if you feel like you may have experienced retaliation at work, just know that you are not alone. You are not alone and help is out there. And now you're armored with this really, really powerful information. So you're better equipped to go back into your workplace and either defend yourself and your colleagues or pursue a legal claim if need be. All right, remember that everyone works, but not everyone is safe at work, and it's on us to know the difference. So go ahead, hit that follow button or subscribe to learn more information about your workers' rights. We'll see you next time. Bye.